E ku iluna. Please rise. Au hea o ko e ko ka aha, I nahe kuliana imua o kea aha ho o kolo kolo ki ike hano hano o ka moku aina o Hawaii. E nai mai, e malio mai, I lohe ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho ilalo. Please be seated.
Please call the case.
Case number SCAP-23-0000540. Blossom Bell, Appellant Appellee versus Hawaiʻi Public Housing Authority, Appellee Appellant. Arguing for Appellant Hawaiʻi Public Housing Authority, Clement Urbank. Also appearing, Chase Suzumoto. Arguing for Appellee Blossom Bell, Nick Severson. Also appearing, Cynthia Moore. Argument on the merits.
All right. Good morning and aloha, everyone. The court's excited to be here today at Mililani High School as part of the Courts in the Community program. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? All right. We've allocated 30 minutes to each side for argument. Mr. Urbank, you're going to have 23 minutes initially and 7 minutes reserved for rebuttal, correct? All right. And then Mr. Severson, you have 30 minutes. We're going to give you a warning with 5 minutes to go, correct? All right. Please proceed. Thank you.
Good morning, Your Honors. Deputy Attorneys General Clement Urbank and Chase Suzumoto for the Hawaii Public Housing Authority. Hawaii Public Housing Authority has a duty, and that's to provide safe, decent, and sanitary housing for all of its tenants. And the HPHA does strive to provide a safe environment to all of its tenants. Every HPHA tenant must sign a rental agreement and agree specifically to this provision. Tenant shall assure that no tenant, member of the tenant's household, guest or visitor of the tenant, or member of the household, or any other person under a tenant's control engages in any criminal activity or conduct that threatens the health, safety, or right to peaceful enjoyment of the premises by other residents. Bell's counsel will tell you that Bell lived in public housing as a tenant for over 40 years without incident. However, Bell signed her most recent rental agreement in September 22nd, 2016, and agreed to assure that none of her guests would engage in violent criminal activity or conduct that threatens the health, safety, and right to peaceful enjoyment of other residents. But on May 12, 2020, the health, safety, and peace of the project where Bell lived was shattered when Bell's unauthorized guest, Daniel Lambert, beat their neighbor into a coma with a baseball bat in front of the tenant's wife and minor daughter. The facts here are undisputed. Daniel Lambert was the guest and son-in-law of Blossom Bell. Bell allowed him to stay in her unit without authorization.
When you say without authorization, what do you mean? Could she not have guests for a short period of time overnight?
For an extended period of time. Tenants are permitted to have guests without authorization for a short period of time, but not long term.
And does the record reflect anything about how long he was there other than he was there that day?
Yes, there was testimony that he was on the property for years, and the eviction board also found that he was an unauthorized guest.
Thank you.
Well, the stipulation was he was there overnight, and according to your own rules, no permission was required, yet that charge was sustained against him. What was the evidence for that?
So that was on the remand. At the remand hearing, that stipulation provided so, but the eviction board at the first hearing found and concluded that he was there without authorization.
Was that part of the findings of fact Because it seemed to only hold that he was there overnight, and the rules provided for that. No permission was required.
I believe only the matter was not challenged and was not on appeal at the remand circuit court appeal. But initially, the board found that he was an unauthorized guest.
Based on what? He was only there overnight. That's the findings.
Based on the testimony by Aaron George, who testified that that Lambert was living at the tenant's unit for an extended period of time, and based on the testimony of his daughter, who also said that she had seen him in the property for years, since at least 2016 was her testimony.
I didn't see that in the findings. Was that part of the findings? I know you're referring to testimony, but did that make it into the findings of fact?
I know that the board did make a conclusion that he was an unauthorized guest. I do not have the specific finding.
Thank you.
Mr. Urbank, you argue that your client has a duty to provide a safe environment, but those duties are spelled out pursuant to the agreements as well as the admission and continued occupancy policy. Isn't that correct?
The duty is actually imposed by HUD, by regulation, in specifically 24 CFR 966.4, which deals with rental agreements, provide that the rental agreement must include a provision that the Public Housing Authority will provide safe, decent, and sanitary housing for its tenants.
Doesn't the policy, and I'm just going to call it the policy for short, where in your argument, in your position, where does the policy come in terms of setting forth the duties of your client, the agency?
A duty is incorporated in both the Hawaii administrative rules as well as the document entitled Admissions and Occupancy and Continued Occupancy Policy. However, to clarify, both the administrative rules and the Admissions and Continued Occupancy Policy, or ACOP as it's known for short, both together constitute the totality of the admissions and continued occupancy policy.
So the lower court, in remanding back to the board, held that the ACOP needed to be applied, which is what happened during the second hearing before the board, the eviction board, correct?
That is correct, Your Honor.
And the holding that the ACOP applied, the circuit court's holding with regards to the applicability of the ACOP was not further challenged or appealed.
That is correct, Your Honor. The reason the HPHA did not challenge it because the HPHA was convinced that Blossom Bell has violated her rental agreement and did not cure it as asserted by her under either the Hawaii administrative rules or the ACOP.
Okay, so you're saying there's no cure when there's a criminal activity violation. You know, let's say a tenant on the property sells cigarettes to a 17-year-old, and the tenant's alerted to this. Hey, that person can't be around. The tenant says, I have banished this guest. This guest is never going to come around again. By virtue of that criminal activity, is it your position that this is just a non-curable activity subject to eviction? The person's out. One strike and you're out.
Our argument is that, so if I understand correctly, that the crime would be the person smoking within the reach of a minor?
A guest sells cigarettes to a 17-year-old on the property. If you're responsible for that guest, much as Bell was responsible for Lambert, doesn't it follow along your position that any criminal activity, the person's out?
No, it has to threaten the health, safety, and right to peaceful enjoyment of the residents. And that is something that's within the discretion of the eviction board to determine.
Okay, so that's okay. Now let's say a guest near the elevator punches a woman and takes her purse. The tenant knows nothing about that. Tenant just gets pissed off at this guest. You're not going to come around anymore. Same thing. that tenant gets evicted?
That's correct, and that was upheld by the United States Supreme Court in the 2002 Rucker decision, which stated that.
I know what Rucker stated now, but doesn't Rucker also recognize the public housing authority's ability to consider the circumstances surrounding the violation?
That is correct. Rucker does provide, as does the USC as well as the CFRs, that the public housing authorities do have discretion to determine how they will proceed in those cases. And the Hawaii Public Housing Authority has exercised that discretion by adopting administrative rules and the rental agreement, which provide that criminal activity or conduct that does threaten health, safety, or peaceful enjoyment of other tenants will lead to immediate eviction without an opportunity to cure.
I understand that. I understand. Am I on? Can you hear me?
You are now.
During the initial hearing, the issue was what applied, the regulations or the ACOP. On the appeal to the circuit court decided that the cure provisions of the ACOP would apply. You did not appeal that decision, so the only issue before the board on remand was whether or not this was a curable violation under the ACOP, right?
Yes, Your Honor. So the Hawaii Public Housing Authority eviction board followed the circuit court's order and did apply the ACOP provision, which under the ACOP actually applies to the notice stage when the manager of the property issues a notice, would determine whether the violation can be cured and potentially provide an opportunity to cure or not.
Basically, your position was that this was not a curable offense. In no way was this curable.
That's correct. The position was that there was no ability for Bell to cure the violent conduct that her son-in-law has engaged in that left lasting and immediate consequences that could not be cured, such as the beating with the baseball bat, as well as the impact that it had on the family that witnessed the assault and burglary.
Why is that? Why is that not curable? Why is her action of ordering her son-in-law off the property not a reasonable cure in this circumstance?
In this circumstance, it's not reasonable because the rental agreement provides that for strict liability, that if such conduct and such consequences occur, the immediate process is to proceed to an eviction.
Again, you're now citing to the rental agreement again. But on the only issue, the circuit court held that it was the ACOP that applies. The ACOP does have cure provisions, and there was a conflict between the agreement, the regs, and the ACOP. But you did not appeal the decision that it was the ACOP that applied.
Yes, Your Honor. However, the ACOP in Section B of Chapter 12 provides that the most recent or the most current rental agreement shall be the document guiding the eviction. And the most recent rental agreement that in 2016 Blossom Bell signed contained this zero tolerance policy. So she agreed to the fact that she will not have an opportunity to cure. And while the ninth type of violation in ACOP Chapter 12, Table C, the table on page 12-6 in Section C does provide for up to 30 days to cure unless management can justify justify the deviation from the 30 days. In this case, the management did justify the deviation clearly by stating in the notice of violation and proposed termination on January 29, 2021, that threatening the lives of other residents and agents of the Hawaii Public Housing Authority is a criminal act, the violation of Section 13Q of the rental agreement, and criminal acts will not be tolerated by the HPHA.
Mr. Urban, can I ask you, what if Mr. Lambert ran out of the apartment after the assault took place and engaged ultimately in a gunfight with HPD and was shot to death during the course of that fight? So he's no longer alive. Would it still be uncurable? And if so, why?
Yes.
He's not alive. He cannot come back.
Yes, Your Honor, it would still be uncurable
Why is that?
because a criminal violation has occurred, and that was the agreement that Bell made with.
But what policy does that serve? That's to punish her for being a bad tenant? What are we trying? What is the housing authority trying to achieve in that circumstance?
Housing authority is trying to achieve what Rucker said, that regardless of knowledge, a tenant who cannot control drug crime or other criminal activities by a household member which threaten health or safety of other residents is a threat to other residents and the project.
So the inference is that because she fell short this one time, she might fall short again, and that's it. She's out. I mean, that's a blunt way to put it, but is that true?
Your Honor, certainly there is an inference there.
Because I'm trying to understand, is this about concern about Mr. Lambert coming back, and the order to him not to come back is people are, the board is worried about whether that's truly effective, or is this about, really doesn't matter whether Mr. Lambert is out there to come back or not? This is about Ms. Bell not being a suitable tenant because of what happened on this one occasion. Which of those two is it?
Yes, Your Honor. The bottom line is that under the law, the rental agreement and the policy, the eviction was proper because this event occurred. So ultimately, whether Lambert would potentially return in the future or not is really immaterial to violation.
What does curable mean? How is that defined? How is that being used?
Okay.
It's not clear to me.
Thank you, Your Honor. So the ACOP, which the Circuit Court ordered the HPHA to consider, specifically provides in the 7th type potential threats and provides certain examples which can be cured, such as it enumerates slip and fall situations, fire hazard, a vicious animal.
So if somebody slipped and fell, and then they clean up whatever it was that caused that, it's already happened. You can't go back in time.
Correct, Your Honor.
You can't undo it, and that seemed to be the board's reasoning. You can't undo something, so therefore it can't be cured.
Yes,
So
Your
how
Honor.
does that make sense?
Well, that would not be a potential, Your Honor. So the potential would be if someone just constantly keeps,
Somebody already fell already and got hurt.
if someone already
It already
fell,
happened.
Yes, Your Honor. If someone already fell, that would have fallen into the 9th type. It wouldn't be considered a potential threat anymore because health and safety has already been endangered by the action of.
Is that curable when you can't undo what happened?
No, Your Honor.
On that category 9, it says 30 days or less if it's justified. That seems to presume it's something greater than 0 and no more than 30. Isn't that a way it can be read?
That's the way it can be read, but we would not agree with that. We would argue that
Is
it's
it at least ambiguous?
no. We would argue that it's not ambiguous. It can mean more, but it can also mean 0. And in,
Well, if you look at the progression, it goes from 0, 0, 0, the first 6 categories are 0, then it goes to 24 hours, and then it goes to 14 days, and then it goes to 30. Why would you read 0 into the 30? That doesn't seem to make logical sense.
yes, Your Honor, because the first 6 categories provide 0 because it's only 0. There's no deviation from that. Whereas the 9th,
Liability,
I'm sorry, Your Honor,
strict liability.
strict liability for those first 6. But for the last one, it depends on the type of conduct. So it's not every type of an incident can be enumerated into a table. So it's a provision that catches everything, and it can be anywhere between 0 days, such as in Bell's case, or it can be 30 days if it's a violation that can be that is not, considered as serious.
So it is your position that the Public Housing Authority has the discretion to make anything a strict liability offense. It has the absolute discretion to make anything a strict liability offense that is not curable.
The Public Housing Authority has the duty to provide reasonable terms, but this particular term that imposes strict liability is required by HUD. The law was really passed, and the title of that law talks about drugs, right? The purpose of the law was to stop drug activity and related criminal activity. Wasn't that the intent of the law, was to stop drug activity, possession, sale, consumption of drugs on public housing projects? And the cases are dealing with guns that are being used by people that are doing or selling or possessing large amounts of drugs, right? Your Honor, it applies to both and independently. There was no intention in the law to only apply to criminal activity if it's collateral to drug activity. And for example, the Scarborough case, which we cited, in that case, the violation was just a loaded shotgun on the premises. There was no drugs implicated at any point, and the D.C. court held that the tenant was strictly liable because should not have the shotgun present, even though she did not know about it, even though her boyfriend used it in the course of defending her and killing her boyfriend, her cousin, in the course of the act. She was liable for the violation of the rental agreement, and we argue that the same principle applies here.
In this case, Mr. Urbank, though, the ACOP was adopted by Hawaii's housing authority, correct?
That's correct.
And I think if I read some of the materials in the case, the particular one that applies here may not exist anymore. I'm not sure, but clearly the ACOP in this record applies. So it's up to the housing authority, the Hawaii Housing Authority, to adopt an appropriate ACOP, correct?
That is correct, Your Honor.
Okay, but we must apply the one that is in the record here. And the one that's in the record here, I think, is pointed out by some of the justices. You're pointing to the violation that allows 30 days to cure, or, as you have argued, the discretion of the board to provide no opportunity to cure. That's your argument, right, under this ACOP?
That is, Your Honor.
And so then we are looking at whether the housing agency abused its discretion in this case.
Yes, Your Honor, and that's why we argue that Bell did sign a rental agreement agreeing that she's going to be strictly liable for her guests or anyone in her household when it comes to violent criminal activity.
Let me ask you this. I wonder about that, because if you look at 8B and 13Q, 8B talks about failing to ensure that the guest doesn't engage in criminal activity, and 13Q1 likewise says assure. So is there any evidence that Bell failed to ensure? I mean, what's she supposed to do? Get in between the two? Take the bat away? Don't you need something there that she failed to ensure if your whole thing is on the rental agreement?
No, Your Honor. Failure to assure was simply that the act happened. She had all the opportunity to sit any of her visitors, guests, household members down and read the provision to them and tell them, if you engage in something like this, I'm going to be evicted for your behavior. So that was her opportunity, technically, to do it. And as the case law provides, the knowledge of the incident itself is...
So she doesn't have to engage in any kind of conduct herself as far as with respect to the guest. Your premise is this is just not a curable offense, right?
That is correct, Your Honor.
Okay.
And there's a reason for that, and that is that the tenant is ultimately the only person that has a relationship with the housing authority, a contractual relationship. That's why they're there. That's why anyone that visits them is there. It's based on their relationship. And if the housing authority cannot hold the tenant accountable, then whom?
Let's say that a tenant decides to have a birthday party for their grandchild, and some people are invited, and somebody is in the parking lot and gets into an argument with another tenant in the parking lot, and they end up in a scuffle, and there's one punch, and we've had cases where one punch can actually kill somebody, right? And this happens, and the tenant doesn't really even know this person. But you're saying strict liability because this was this tenant's guest. You would have the discretion to say that this person that lived in public housing for 41 years with no problems is now subject to eviction.
Yes, Your Honor. And the reason is that this is the notice to all tenants to assure that this does not happen, because that's the only way for the HPHA to be able to.
So basically, you're saying tenants should never have guests over, just in case their guests hit or hurt somebody.
No, Your Honor. I'm saying that the tenants should not have guests over who intend to injure or kill other public housing tenants.
Well, you know, let's say we disagree with you and that the board, after finding a violation, does have some discretion, as Rucker suggests. Does an agency abuse its discretion when it believes it cannot exercise discretion?
I believe that in this case, the agency did exercise its discretion, Your Honor.
Well, it thought it had no choice. It thought, hey, if this is a non-curable offense, she needs to go. That means that they thought they had no discretion in allowing her to stay. Is that an abuse of discretion if we think that if the board did have discretion?
No, Your Honor, I don't believe so. And I believe that the discretion that the focus should be on would be that it was the intent of the Hawaii Public Housing Authority's Board of Directors to adopt the policy which requires certain offenses to be non-curable that particularly include violent criminal activity.
If it's a criminal activity, can the board still consider mitigating factors? Like in this case, you have a tenant who's been living there for 40-something years, seems to be a model tenant, unblemished record. Maybe she was late for one payment, but otherwise hasn't caused any problems, hasn't gotten into any trouble. Is that something the board can consider even if it involves criminal activity?
No, Your Honor. I think it's comparable as to how a criminal court cannot consider if someone is convicted of murder in the second degree to not impose life in prison with the possibility of parole.
You know, the judge seemed to be making a distinction that it wasn't actually Ms. Bell that went into the house and was involved in the assault. What was your response to that?
Response is that she agreed in her rental agreement to assure.
Doesn't the agreement also call for some sort of control? You were talking earlier about the tenant being able to hold someone accountable, whether it's a guest, household member, and so on. But there's some degree of control. Isn't that what the agreement also calls for?
No, Your Honor. The agreement strictly calls for liability for any violent criminal activity that occurs. I believe, unless Your Honor is referring to the section that says, or any other person under tenant's control, but that specifically just means someone that would not be in the category of household member or visitor or guest.
So control is needed for those circumstances, but not the others?
No, Your Honor, that's not how that is applied. And
Well, that's what I'm trying to find out. What does control apply to? All categories, or just any other?
No, control only applies to this last category.
Thank you.
So your position is the board cannot consider the circumstances. It's okay for the board to not consider the surrounding circumstances, whatever they might be. 41 years, say she ran down and tried to drag him out of the apartment before the assault occurred. None of that is going to matter because it's the nature of the offense. Is that the board's position?
Your Honor, the position is that if the board, after considering all the factors, determines that violent criminal activity has occurred that did threaten health, safety, or right to peaceful enjoyment of other residents, it cannot not impose eviction.
Very well.
All right. So your treating the number, category 7 and the ACOP as something, it says threaten the health safety. It seems to me, based on that, it's really looking at future activity, whether there's something that's going to be a threat. But you're saying that this applies, but even for that, there's a 24-hour opportunity to cure, right? So if there's an 24-hour opportunity to cure, how can it suggests that the threat is something that is existing and continuing? So I'm a little bit confused as to whether that can even apply, actually.
Your Honor, I think the important word which Bell's counsel continues to intentionally omit from their argument in the 7th type is potentially threatens. So that's the distinction. It has to potentially threaten. Nothing has happened yet. If there's a vicious dog barking, growling at other tenants, and someone reports it to the management office and says, this tenant has a dog that keeps growling at me, I'm afraid they're going to bite me, that would be a notice that would say remove the dog or we will proceed with eviction. If they remove the dog within the 24-hour period, the threat has been eliminated, so there's no more potential threat. However, the 9th type would apply if this dog actually bit the neighbor, then the injury has occurred and the person would be referred for eviction.
Mr. Urbank, we're up against the 30 minutes. Anything further at this point, or do you want to save that time for rebuttal? And I'll give you a little extra time as well. But got a little time left.
Rebuttal, Your Honor. Thank
All right, thank you. All right, Mr. Severson.
Good morning, Chief Justice Rechtenwald, fellow Supreme Court justices, and may it please the Court. The Hawaii Public Housing Authority misapplied the law and ignored its own policies, causing Ms. Bell, a longtime tenant in good standing, to lose her housing. The Admissions and Continued Occupancy Policy, or ACOP, based on federal regulations and guidance, governs public housing evictions. By not giving Ms. Bell the chance to remedy her violation, HPHA violated Ms. Bell's due process rights. Further, Ms. Bell corrected her lease violation in accordance with the ACOP, so her lease should remain reinstated, and this honorable court should uphold the Circuit Court's previous ruling for the following 4 reasons. Number 1, the ACOP is the applicable policy governing public housing evictions, and it's required by federal regulations. Number 2, HPHA failed to apply the ACOP in terminating Ms. Bell's tenancy. Number 3, Ms. Bell's lease violation was curable, and she remedied it in accordance with the ACOP. And 4, HPHA's failure to provide notice and an opportunity to cure violated Ms. Bell's due process rights. HPHA cannot arbitrarily apply other laws or override federal regulations and HUD requirements in affecting an outcome of eviction.
The Housing Authority argues that it has a duty to protect the other tenants who live in the housing area, and pursuant to the rental agreement, it seems like under paragraph 19 it says they will seek to terminate when a situation like this occurs. How do you respond to that argument that they have a duty under their rental agreement and the laws that apply here?
Yes, Your Honor. They certainly have a duty to protect the other tenants on the property. However, they need to do so in accordance with the applicable law. And as this Court correctly noted during Mr. Urbank's argument, the issue of whether or not the ACOP applies is not on appeal here. HPHA has not appealed that issue. So the Circuit Court correctly found in the initial Chapter 91 appeal that the ACOP applies. So HPHA needs to apply the ACOP in affecting a tenant's eviction. And to the extent that tenants violate a lease in a way that threatens the health and safety of other tenants, for example.
But they're saying they applied it. They're using category number 9. I think they conceded number 9 would apply. And that goes from, they're saying from 0 to 30, and they're picking 0. What's your response to that?
First response to that, Your Honor, would be that they acknowledge in their own reply brief, and I would point the Court to page 1 of their reply brief, where they, and I'm finding the exact quote here, they state that this violation was of the nature that, quote, threatened the health, safety, and right to peaceful enjoyment of other residents. So it seems like in some cases they're arguing that it's a health and safety violation or threatens health and safety violation. In other cases they're arguing it fits into this final kind of catch-all category. But to your point that you made, Justice Evans, in your questioning of Mr. Urbank, there's an implied curability period that comes with that 9th category. As you noted, the way that the ACOP lays out the specific violations and remedies, they define 9 specific categories. They define 6 of those categories as expressly non-curable. They then go on to provide increased time periods for curability for these other types of violation, culminating in the 9th violation.
Right, but what about their argument? They're saying that, okay, you have time, but you just can't cure it. What you did was not curing what happened. You can't undo. That's pretty much their argument. What's your response to that?
And that's a question I would point the court back to what Justice Ashford correctly held in the Second Circuit Court decision, which is that the violation is Ms. Bell's control of the guest. She is not the one that entered into the unit and committed to the assault.
The agreement says she's responsible for the guest, and this was a guest. There's no question about that.
Yes, Your Honor. But again, this is where we're going with conflicting policies and conflicting language that the
rental agreement's pretty clear on that. Responsibility for guests.
Sure, and the rental agreement conflicts with the Hawaii administrative rules and conflicts with the ACOP, and we're talking about what a tenant is supposed to have notice of and be aware of in terms of how they are to conduct themselves and respond to a situation. So to the extent that these policies are conflicting and create confusion, that is a problem that HPHA has the capacity and has the discretion to address in promulgating and developing their ACOP in a way.
Due process notice issue for you?
There is. They've never attempted to adequately define the nature of the violation and the time period to cure, which is something that I'd point the court to, and this is in Chapter 12, subsection C of the ACOP, which states that in case of any default by the tenant in the payment of rent or other observance and performance of any covenant under the rental agreement, the PHA shall notify the tenant of the default in writing and shall specify the time within which the default and noncompliance must be remedied and corrected. That never occurred in this case. So,
did you ever notify her that it was 0 days?
Not in the notice prior to her rental agreement termination.
Thank you.
Correct. So as I was saying, the ACOP is the applicable policy for governing rental agreement terminations and evictions, and that's for a number of reasons which we articulated in our briefing. Specifically, it's contained as a provision of 24 CFR section 903.1. It's further outlined in Chapter 1C of the ACOP itself, which states, and I'll also quote this for the court, that the purpose of the admissions and continuing occupancy policy is to establish the guidelines for PHA staff to follow in determining eligibility for admission and continuing occupancy. Goes on to state that these policies and procedures for admissions and continued occupancy are binding upon applicants, residents, and the PHA.
Mr. Severson, what if incidents keep happening repeatedly with a tenant involving various guests, and the tenant each time says, I told them they can't come back, and then a couple weeks later another guest comes, gets in a fight. Well, I told them they can't come back. At what point can the board say, enough, you have to leave this property? Is that something they can do in your view?
So there is language in Chapter 12 of the ACOP about repeat violations, but to the extent that HPHA has the discretion to again, promulgate the ACOP and use that as the governing document for evictions. That's where their discretion lies, not in avoiding the consequences and the framework of the ACOP that they have chosen to define. They're the ones that have chosen to develop and make these rules. And they do not have the discretion to disregard those policies to affect a different outcome, even if it's an outcome they may prefer.
Counsel, the Circuit Court on the first appeal held that this is governed by the ACOP and remanded. That issue was not appealed. Does this court need to address whether or not it is the ACOP or the rental agreement or the regulations that govern? Or are you asking that we rule based on the stipulation, based on the initial ruling, that the ACOP applies and not address that issue?
We believe that the issue of whether the ACOP applies is settled and is not before this court because it was not appealed by the Public Housing Authority. Really what's before this court today is whether Ms. Bell sufficiently cured her lease violation in accordance with the ACOP, which was the second point of my argument. The ACOP, as you know, defines curable and non-curable violations. We believe that this violation is a violation in the nature of health and safety, requiring a 24-hour time period to remedy, which was also affirmed by the Circuit Court. As I mentioned earlier in my argument, HPHA acknowledges in their reply brief that it's of the nature that threatens health and safety. The parties stipulated to the facts, which this court knows, and the offending guest was removed within 24 hours. There's no dispute about that. So at this point, the eviction board getting to the eviction hearing and reaching the conclusion that it's secure but not the cure that's envisioned, which is a quote.
Wait, can I ask you about that?
Yes.
Did they ever say what was the proper cure or what was envisioned?
At no point was it made clear to Ms. Bell what the proper cure that was envisioned was. So Ms. Bell has done everything in her power to cure, absent any more clear notice from the Public Housing Authority as to what would constitute a proper cure, which I'll remind this court was part of their requirement under Chapter 12, Section C of the ACOP to provide that notice and define the time period to cure.
So you're saying that under C, it says the tenant shall be notified of specified time to remedy the violation as follows, and then it refers to categories 1 through 9.
That's correct.
Are any one of those categories referenced in the notice of violation issued in January of 2021, giving her notice of which category she was being alleged to have violated?
They were not, Your Honor.
Counsel, what's your position with regards to Rucker and how Rucker should apply to this case?
Yes. We agree with the point that Justice McKenna had made earlier in the questioning of Mr. Urbank about the purpose of the law underlying the Rucker decision, which was to prevent drug-related criminal activity on the property. There's specific post-Rucker guidance from HUD that talks about there being that the PHAs have the discretion to determine other factors and that it's not an automatic reason to evict a tenant based solely on a violation of that, which I'd also point the court to a decision in it's Kentucky decision that we cited in some of our briefing, which is the Housing Authority of Covington versus Turner case, which actually has some similar sort of parallels to this case. And in that case, Turner's guest, who was her nephew, was involved in drug-related criminal activity on the property, and that court there affirmed that the Supreme Court expressly left discretion to the states and local authorities to consider the circumstances and extent to which the leaseholder has taken all reasonable steps to prevent and mitigate the offending actions.
I'm sorry.
Sorry, one quick follow-up. One of the things that Rucker says, and I think the Housing Authority points to, is the reason why the kind of lease terms that apply here do, and it makes sense for Congress to allow for it, is that somebody who cannot control others who commit criminal activity are themselves a threat to others who are at the Housing Authority. That's what the agency points to, right? So why does that not apply here?
So to the extent that HPHA needs to reckon with Rucker and the implications of that, they've done so in the ACOP, and I would point the court to the second category of violation, which defines any drug-related criminal activity on or off the project premises and provides a 0-day curability period.
So we go right back to the ACOP.
That's correct.
But, you know, the Turner case, the Kentucky case, the court actually noted that I believe the rental agreement there allowed incorporated remedies or tenant remedies under the Kentucky residential landlord-tenant law. Here, our residential landlord-tenant code has a specific exclusion for public housing. However, I also believe that the regulations appear to allow consideration of other laws. Would that be an accurate understanding? Does the law, can we consider other laws even though we can't consider remedies under the residential landlord-tenant code? Other potentially applicable laws? such as you're citing to the Constitution, so we're talking about due process.
Yes, I think that's correct, Your Honor. And just going back to the point that you made about perhaps in the Kentucky case there being a definition about what the remedy would be, I would just like to note for the court again that that was absent at any point in this case as to what the cure or curability period would be for Ms. Bell, which kind of takes us back to our central due process.
The reason I asked that question is I was wondering, would one of the laws that we might be able to consider be the Aloha Spirit Law? That the courts and agencies should be guided by the Aloha Spirit in making its decisions.
I think the court can, I think that there should be some consideration given to the circumstances and what Ms. Bell did to correct the issue here.
Well, I'm sorry, go ahead, sir.
Your position is that the ACOP, the policies, could have provided for no cure, but they weren't explicit enough to do that in these circumstances? Is that the bottom line for you?
That's correct, and it's clear from the ACOP as it existed at the time itself. There's 6 categories that are expressly defined as non-curable. So HPHA, in their discretion, decided for one reason or another not to define a violation of this nature in that same manner. So they're bound by the fact that they did not exercise the discretion to do so here.
All right, thank you.
You know, the board in their supplemental decision, they gave the example if you had someone unauthorized coming onto the property and you tell them to leave, even though they had already trespassed or they weren't there with permission, you can't undo that, but that would cure that situation. But if someone enters the house, they don't do anything, but they go into someone else's house, but they immediately turn around and leave, you can't cure that. What's the difference between those two?
Could you repeat the question?
The board gave the example of what can be cured, and they said if someone unauthorized came onto the property, the housing property, and you told them to leave, that cured that situation. But if they went into a tenant's home, but immediately turned around and left, didn't cause any harm, didn't cause any trouble, you couldn't cure that by telling them to leave. What's the difference between those two scenarios that the board gave?
I think, and I'm hoping that I answer your question here, so please let me know if I don't. But to the extent that, say, Mr. Lambert were to come back onto the property in the future, that may constitute some other type of lease violation, and might.
If he just went into the house, he wanted to have words with the guy, but then he changes his mind. Ms. Bell tells him, "Get out, leave," and he immediately turns around and leaves the residence. Would that be considered a cure, or that's something that's not curable because it already happened?
If he was excluded from the property, it would be cured. If he were to come back onto the property, I think there would be an argument that would no longer be a cure. But in this case, we have 4+ years since the incident occurred. There's nothing in the record to suggest that he's come back on the property or created any future issues. So we would argue that that is a sufficient cure in accordance to the ACOP, especially in light of the fact that HPHA at no point made any attempt to define what a cure would be or what a cure would constitute. So Ms. Bell can't be expected to intuit what the Public Housing Authority thinks is a sufficient cure for a particular type of lease violation.
Did the board ever explain what would justify going less than 30 days under Category 9? What would constitute a justification for deviating?
I do not believe they did.
I noticed that the rental agreement and the federal law incorporates protections for victims of domestic violence. Let's say that in this situation, the son-in-law was visiting, and Mr. George, the downstairs tenant, was also visiting, and then the son-in-law started getting upset and started, hitting and shoving family members, and also hit the guest. Would that be covered by the domestic violence exclusion?
If you take HPHA's argument to their logical conclusion, you would have to evict Ms. Bell and other household members for that same type of violation, even if it were a domestic violence situation, which is why their argument has to fail here. It's important for that consideration to be given to the circumstances, and it's clear that Ms. Bell did everything in her power that she could have to cure the violation that occurred here, which was having Mr. Lambert on the property, learning of the fact that he had committed a crime, and immediately excluding him from the property. So as I mentioned, Bell's violation was curable, and she clearly remedied violation in accordance with the ACOP. The violation was permitting the guest onto the property. She took immediate action to remove and exclude the guest from the property.
Can I ask you this? You know, let's put the ACOP aside. And as far as I understand, the ACOP's been rescinded, and it's no longer practice to give an ACOP to a new public housing occupant. You know, so if you look at the Hawaii regulations, 17, 20, 30, 33, you look at the federal regulations, you look at the federal law, 42 U.S.C. 1437, all of those essentially say that it's one strike and you're out, there's no cure. Isn't that accurate? I mean, if the ACOP's not around, isn't the person out if there's criminal activity?
So as you noted, the HPHA has since amended their ACOP to refer Chapter 12 to the sites that you acknowledge in the administrative rules, which is 17-2020-33, which, if these same facts were present in today's world under the regime of the new ACOP or the sort of circular reference to the HAR as it currently exists, it might achieve a different outcome because the curability and non-curability definitions contained in 17-2020-33 are different. So that is
So as it stands today and moving forward, Ms. Bell, under today's landscape, she'd be out, right? As would anybody who is allowed or failed to assure that a guest refrained from criminal activity. They're out, right?
I think that would be consistent with the reading of HAR 17-2020-33, but I think, again, to point back to both the Housing Authority of Covington versus Turner case as well as...
And that's what I wanted to get to, because those cases, and including Rucker, do suggest that the board does have some discretion later to consider, you know, mitigation, 41 years residence, whatever you want. So can you explain how that then works? Because on the one hand, you're saying they're automatically out, no curability, but it does seem there is some discretion that the board has.
Yes, that's correct, and both the Rucker decision as well as the Turner decision, as well as the subsequent HUD guidance that we alluded to, all makes clear that there is some discretion in there. HPHA at no point in the findings of fact or in the eviction board hearing itself appeared to give any consideration to that. The actions that Ms. Bell took.
Did it appear to you that the board thought they absolutely had no discretion there?
That's how it appeared to us. It appeared that would be the conclusion that they thought they had to achieve, is that this type of conduct results in termination, regardless of consideration of the circumstance.
And if a board feels they have no discretion and that's how they act and that's how they operate, but they really did have discretion, is that an abuse of their discretion?
We would argue that that could be considered an abuse of discretion.
Thank you.
Yes. So as I mentioned earlier, the only cure for Bell in this circumstance would be to remove the offending guest from the property. She's done so, and he's remained off the property for some time. The last point that I wanted to address is that HPHA failed to provide notice and an opportunity to cure, and how that violated Ms. Bell's due process. I know we've talked about this a bit throughout the questioning here. But HPHA does not have the discretion to selectively enforce their policy. It's clear from the Circuit Court's earlier decision that the ACOP applies. They don't get to choose when they want to apply it or when they don't want to apply it. The ACOP provides that the PHA shall notify the tenant of the default in writing and shall specify the time within which the default and noncompliance must be remedied or corrected. That's contained in the ACOP itself. As Justice Edens pointed out earlier, that's not, or in his questioning, we discussed how that was not done. Proper application of the ACOP could only result in one outcome, which is determine that Bell cured and should not have been evicted, consistent with that seventh category, the 24-hour time period to cure for a threat of health and safety. And again, the threat of health and safety is Mr. Lambert remaining on the property, and she remedied that within that time period by excluding him. As we've also pointed out, HPHA has the discretion to amend their ACOP, and as we've noted here today, they have done so, but they can't avoid applying it and applying the appropriate policy, or applying a different policy to achieve their desired outcome. And the last thing I would just want to to talk about a little bit here is if this court is to determine that the ACOP doesn't apply or that this cure doesn't constitute, what does this mean for public housing tenants? And I think under the current landscape with conflicting language in the ACOP, in the administrative rules, in leases, in court decisions, tenants are left with little guidance as to what is going to be the policy that they're going to be subject to and how their leases may or may not be impacted by conduct of household members or of guests. So it's really important to consider the broad policy ramifications of permitting an agency to selectively choose which policies to apply in different situations to affect the outcomes they want, and how that could lead to arbitrary and capricious enforcement impacting certain tenants more than others. So in conclusion, I would just like to say that HPHA's misapplication of the law resulted in the unlawful termination of Ms. Bell. If this court does not affirm the prior decisions of the Circuit Court, countless public housing tenants will continue to be subjected to unclear, inconsistent, and arbitrary policies and procedures, resulting in the possible loss of their federally subsidized housing. It is paramount for this court to ensure that the state's largest housing provider complies with the relevant law and treats their tenants with respect and dignity they deserve. As this honorable court previously noted in the Colillo case, quote, even though HPHA has an important interest in maintaining the peace and safety of the projects, HPHA must abide by the rules and provisions that create the boundaries of its discretion, especially where the consequences of this action are so dire, end quote. There is nothing more dire than for a 65-year-old tenant of 40-plus years for being evicted due to HPHA's failure to apply the required policies. Accordingly, we ask this court to affirm the Circuit Court, and I thank you unless you have any further questions.
All right. Thank you, Mr. Severson. Mr. Urbank, your rebuttal. So I'm going to give you a little bit extra time, but I ask that you keep it down to 2-3 minutes max, please. You're only got 23 seconds left technically, but I want to give you a little bit of time to respond.
Thank you, Your Honor. Your Honors, I would just like to clarify that VAWA, of course, or Violence Against Women Act, would absolutely protect a victim of any violence that is covered by the act, should that be the criminal violation in question. So that would not lead to an eviction. The HPHA has, in fact, complied with all the law, the federal law, the state law, as well as the rental agreement. Blossom Bell has agreed to subject herself to the rental agreement. She signed it. She said that she would assure that no one would engage in the conduct that happened. And also Section 19 of the rental agreement specifically says management will immediately seek termination of this rental agreement for criminal activity as described in paragraph 13. It doesn't get any more clear than that. In addition, Chapter 12...
But what he's saying is there are other provisions that sort of cut the other way, and if there are multiple provisions pointing in different directions, the tenant should have the benefit of, I guess you would say, the more favorable provision for her, or at least shouldn't be held accountable for being confused in a circumstance where she might reasonably be confused. What's your answer to that?
The answer is that the conduct here was strictly within the scope of Section 13Q1, and she agreed to be liable for that. And she agreed to be immediately referred to eviction for that, and she was. And also we argue that ACOP Chapter 12C should be read or must be read in conjunction with ACOP Chapter 12B, which provides termination of tenancy will be in accordance with the PHA's most current rental agreement. So the provisions of the rental agreement certainly have to be considered when the types of violations enumerated in Section C are contemplated by the board. We'd also argue that the eviction board on remand did apply the ACOP and did exercise its discretion, and the order of the eviction board speaks for itself, where the board found that the violation of rental agreement includes Lambert's unauthorized entry into Aaron George's unit and physical assault of George, which resulted in severe physical injury to George. And then they say the only way that the result of Lambert's action could have been cured or remedied would have been for Lambert to unenter George's unit or unassault George, both factual impossibilities. They have contemplated what the conduct caused and how potentially it could have been undone, and determined that it could not have been. They actually go further
You
and
can
say,
never undo any conduct. I mean, once something happens, we can't go back in time. I'm not understanding what this cure means.
the result of the conduct, Your Honor, which is the burglary and assault, felony assault.
Okay, so when the board used the example of someone trespasses onto the property, but you tell them to leave, the trespass has already been completed. You can't undo that part. You can prevent it by telling them don't come back.
If someone first comes onto the property, they have to receive a warning first. So if they leave at that point, Your Honor, they will not be, and actually, if it is a trespasser, that would not be within the purview of the Hawaii Eviction Board to consider. That would be something that HPD would take on.
Let's just say it was an unauthorized entry onto the property. I think that's the way the board characterized it. And they said you can cure that by telling the person to leave. But that's not undoing anything. It already happened. They already came on the property. It was already unauthorized. You see, I don't quite get where you're going with this cure.
Your Honor, just to clarify, is Your Honor asking if the eviction board has ordered someone to stay off? I'm not quite clear about the circumstance.
I'm just using the example they used in the supplemental findings, the decision they issued.
So if a criminal violation or criminal conduct that threatens the health and safety of the residents has occurred, that it cannot be cured. That is correct. That is the policy of the housing authority, as well as the rental agreement so provides.
Right, but that would apply to any activity at all that's already happened.
No, it has to be a criminal activity, Your Honor.
So that's the only ones that can't be cured?
Well, it's specified. It has to be particularly any criminal activity or conduct that threatens the health, safety, or right to peaceful enjoyment of the premises by the residents. So if it falls outside of that scope, then it would not be applicable.
Right, and the ACOP says you have 30 days where you can deviate. Cure.
Well, Your Honor, it says 30 days unless management can justify, and we argue that management has amply justified by both the rental agreement as well as the notice of violation, which was provided to the tenant.
I understand. Thank you.
Thank you, Your Honor.
Mr. Urbank, could you wrap up at this point?
Yes,
with any
Your Honor.
final thoughts for the court?
Thank you, Your Honor. So we'll just argue that the consequences in this case were immediate and lasting upon the Lambert, based on Lambert's crime upon the George's family. George testified at the eviction hearing that the incident affected him badly. He was in the ICU for 4 days, in a coma for a couple of days, had a scar on his head from the bat that Lambert used on him. They used to leave their doors unlocked to get the wind through the unit because it was hot, since it was a ground floor unit, and then they had to start locking everything up and keep an eye out on everyone at the property in fear of being assaulted again. This incident intruded on the sanctity of George's home and basically violated George and his family in the space where they were supposed to have felt safe and where the Hawaii Public Housing Authority had the duty to provide them to be safe. The HPHA strived to guarantee that by asking every tenant to agree to prevent such conduct, and Bell did not do that. For that reason, we ask that the circuit court's decision be reversed and that the eviction order be restored or reinstated, Your Honors.
All right, thank you, Mr. Urbank. The court will take this matter under advisement and issue a decision at a future time. As you tell, this is a very big undertaking to have the court convene away from our courthouse in downtown, and I want to acknowledge the folks who made that happen. I want to start by thanking our attorneys, Mr. Urbank, Mr. Severson, as well as Mr. Suzumoto and Ms. Moore for participating in our argument today. Can you please join me in acknowledging them? On behalf of the court, I want to thank the nearly 400 students and teachers who joined us here today from Mililani, Aiea, McKinley, Leilehua, Radford, and Waipahu High Schools. And I want to give an extra special shout out to Mililani High School for hosting this event here today. We were here when this program was just getting started 10 years ago, and it's exciting to be back here today. So for over a decade now, Courts in the Community, which is what we call these events when we go out around the state to hold oral argument, has provided thousands of students with the opportunity to see what you saw today, which is our justice system in action. You know, public understanding of what we do, how we do it, and what the rule of law means is essential to the well-being of our justice system and essential to the future of our democracy. And I'm really impressed by how attentive all the students were here today. I've heard a lot of good things from the lawyers and teachers who are working with you on this case. I feel like our future is in very, very good hands with you and our teachers, all of whom came together to make this event possible. So can everyone else join me in acknowledging our students and teachers? All right, we have some special guests here today who I wanted to acknowledge. City Council Member Val Okimoto, State of Education Board Member Aline Chung, Representative Kanani Souza, Board of Education Member Aline Chung, Aiea High School Principal Wayne Guevara, UH Law Professor Avi Soifer, the First Assistant Public Defender Haley Chang, Solicitor General Kaliko Fernandez, our former colleague, Richard Pollack, who I understand was one of the folks who went out to the schools. So I want to acknowledge Justice Pollack. A number of people from the Hawaii State Bar Association's board. The Hawaii State Bar Association is the organization of our lawyers in this state. They've been incredibly supportive of this program, and I want to thank Mark Murakami, Jessica Domingo, Ronette Kawakami, and Jocelyn Chong for being here today, and thank the board for its support. I also want to shout out to the folks at Mililani High School who've made this event happen, and we're so grateful to them. Principal Frederick Murphy, Assistant Principal Reed Nonaka, Student Activities Coordinator Danielle Castro, Lieutenant Colonel Timothy Schiller, and the JROTC cadets. Shout out to them for meeting us when we came in today, the custodial and facility staff, all of whom came together and extended a really warm welcome to us. Can you please join me in acknowledging them? I mentioned the William S. Richardson School of Law, and it's a really important institution in our community. I mentioned Dean Avi Soifer used to be the dean there. It is a wonderful law school. 3 of my colleagues here on the court attended that law school, and I want to let you know it's something for those of you who are interested in what you saw today. You should keep in the back of your mind as you go on with your education as maybe something that could be for you. It really is an extraordinary place. They've helped us, the students there, a group called the Students for Public Outreach and Civic Education, helped us prepare today by briefing the case, so they were teaching materials that assisted the lawyers and teachers when they talked to you about the case. I also, super critical, want to thank the volunteer attorneys who went out to the classrooms. That makes this program what it is, which is they give you the opportunity to understand what's going to happen, to have some insight into what's going to happen. So I really want to shout out to them. Please join me in acknowledging them. All right, I'm going to thank our judiciary staff, Kurt Shibata, Tim Kozak, Randy Kuhau, Jan Kagehiro, Richard Katugal, Keahi Davis, Kalea Kau, Ahukini Fuertes, all of our law clerks at the Supreme Court for working hard here today, getting here early to make this happen. I mentioned earlier the Hawaii State Bar Association. I want to thank Ryan Tamura and the Executive Director Kathy Betts for their support and for supporting this effort in a variety of ways, but their foundation supports us through paying for the transportation and lunch costs for the students. So we're very, very grateful to HSBA for that. I also want to extend a big shout out to our MC and moderator, Judge Clarissa Malinau, a proud Trojan. Judge Malinau. And I want to thank Olelo. You know, everything we did here today was being broadcast across the state, is being broadcast across the state. Thanks to Olelo. We have a great partnership with them. We're very grateful for them being here. to help us today with so many different aspects of making this happen from a technological point of view. So mahalo to Olelo, mahalo to their folks, Ku'u Ipo Rossiter, Lindsay Reese, and Jonathan Wong, who are behind the scenes, behind the curtain, behind me. And once again, most important of all, mahalo to our students and our teachers for coming here today and for being really at the forefront of understanding what our democracy is and being able to understand what courts do and what the rule of law means through the hard work you put in to preparing today. So mahalo to each and every one of you, and there being no further business, this court stands adjourned.
Ku Iluna, please rise. Ua ho'o ku'u ia mai ne kea aha ho'o kolo ki ike hano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.